Hi everyone, today I want to discuss with you the doctrine of originality in copyright law with specific focus on the Indian law, where we will ascertain what the doctrine is, why we need this doctrine, and how originality is ascertained in the jurisdiction of UK, US, and then India. First, we need to see that the legislation on copyright that we have is the Copyrights Act 1957. In section 13 mentions to us the subject matter of copyright, that is, in which category will we find that copyright can be taken by the applicant. So if we read section 13, it is works in which copyright subsists, subclause 1. Clause 1. Subject to the provisions of this section and the other provisions of this Act, copyright shall subsist throughout India in the following classes of works, that is to say, subclause A, original literary, dramatic, musical, and artistic works. Then in B, we have cinematograph films, and C, sound recordings. Here we see that the word original has been used with respect to LDMA only, and with respect to cinematographic work and sound recording we don't have this classification. In short, we call this as CFSR. One reason why originality is not made a criteria for these two subject matters is because generally they are based out of scripts, novels, or already written musical notations which get protection under literary work, right? So we see that a very heavy condition has been put before LDMA works to get to become eligible to get copyright protection, and that is that they should be original. However, we will see like throughout the legislation, nowhere the term original or originality has been defined under the act. Hence arises this question, like what is originality and why we need it. So different jurisdictions have taken different method, as we see that in UK we have sweat of the brow, in US we have modicum of creativity, and then we look at India, which is trying to shift forward from sweat of the brow that was implemented in India because we are a former colony and UK laws were applicable, to now modicum of creativity. But to getting back to the first question, like what is originality, and why we need it. So the purpose that originality has been included as a threshold or as the basic qualification limit is because government would try to have a large public domain. Public domain is the information that is available freely in the market that people can use. Like, if this lecture is in public domain, you can use this lecture to further create something on top of it for yourself, or to create further awareness on the topic of doctrine of originality. However, if I get a copyright on my lecture, you cannot use it freely. You need my permission, and it will create hindrances in terms of how information is disseminated to the society further on, right? So government or society would want that as much as is possible we should have a larger public domain, because of which we have come up with the quality of originality, that it is only that the work of highest order or highest qualification should qualify for copyright protection. There is this one example that we can see, like if this is the public domain spectrum, like this is the area where all the public domain information lies, you can add a little bit of your creativity. For say you are paraphrasing whatever is available on a lecture and saying it in your own words, then you have added your own creativity and you have added your originality. Hence, so should you get copyright? What say someone adds a higher order of intellect into their work, and then they come up with something new, like they say something completely opposite to what they are criticizing or what they are relying on. So the level of originality in this work is definitely higher and should be given the protection, because that person must have invested a lot of labor, skill, and judgment to arrive at whatever content they have come up with to create this kind of work available here, right? That's why we need this threshold criteria. Next is, do we have a definition for originality anywhere? The answer is no. because with respect to different subject matters, we have different qualification of originality that we will consider, as we have seen in the case of sound recordings and cinematographic films, that we don't have this qualification required for it to be an original work, right? So giving an overall one definition would be difficult. That's why it's not mentioned. Next we see how uh, originality is ascertained in different jurisdictions. So first we'll begin with UK, and UK follows the sweat of the brow doctrine. Sweat of the brow is like an English idiom which just suggests that you have put in labor into some work, like you have done some labor without any originality or creativity into the work is eligible for protection, right? So if we consider the facts of this case, Feist publication, I'm taking the case for US, right? It's a Feist publication versus rural telephone services. In this case, what happened? The person collected the telephone numbers along with names and addresses of all the people in a particular vicinity and created a directory out of the same and then published it. He claimed copyright over the same. And so you can consider the amount of labor he would have to put into this endeavor to go to each and every house, knock at the house and be like, okay, give me your number, I'm creating this directory, can I use it? And imagine collecting 100 numbers, for example. If he has done so, that would amount to him putting in labor which is eligible for sweat of the brow doctrine, right? But coming back to the cases that we have actually taken for the jurisdiction of UK is Walter versus Lane. So in this case, what happened was, there is a politician who is giving speech, and a newspaper representative is writing down whatever is being given in the speech. For example, मोदी जी अपनी speech दे रहे हैं और मैं बैठ के वहाँ पे लिखे जा रही हूँ जो भी वो बोल रहे हैं. And then since I am a reporter, I go and get it, I annotate it, I give the punctuation that is required, correct the grammar for whatever I've written down, and then get it published. And what happened is, someone is later on creating a book on this particular person, and he uses the this speech that I have converted into newspaper article in the book without my permission. And so I say that you have violated my copyright because I had actually put the labor into writing down the speech at that point and later converted it to an article that you have used without my permission. So the question was whether this article is worthy of getting copyright, because it was verbatim reproduced in a newspaper report. And the court in this case held that the work was protected by copyright because labor has gotten into that work. Next is this another case of University of London Press versus University Tutorial Press, wherein the concept of originality was considered with respect to the facts of the case are like, these are two different universities. There is one Professor A and another is Professor B. They are both maths professor who have set up a question paper on the same subject matter. And since the underlying substance of the subject matter is same, like if I'm taking a paper for addition and I say 3 plus 4 is equal to dash or 5 plus 7 is equal to dash, the nature of the questions would be similar. The values might vary, right? And there is no other way I could be asking this question if I want to go for direct question. However, this was a question paper of a much higher level. And so it was held in this case that there is no breach of copyright in case that the person has individually come up with the same set of questions, because it also says, like, this doctrine of originality would say, if there is person A and there is person B in different cities, they are randomly thinking about writing a poem on apple, and they end up writing the same 3 lines without ever meeting or without ever discussing the same, they are both eligible to have their copyright, because it's the person's labor that has gotten into the work, right? So in this case, the court held that merely because similar questions have been asked by other examiners, the plaintiff shall not be denied copyright. This doctrine is also followed in various other jurisdictions, including Canada, Australia, and India. Next, coming back to US, where we discussed the facts of this case, Feist publication versus rural telephone services, we see that US follows a modicum of creativity as threshold. So it's not merely labor that you can put into the work, there also has to be some sort of creativity. Question arises, what can one mean by creativity? Like, what is creativity in a particular situation? It is very subjective. Ki what amounts to creativity for you might not be creativity for me. We have seen so many art gallery works that have gone up, that are sold for millions of dollars, but we don't understand, like most of us don't understand what is there in this particular piece of art, that it is being sold for such a high value. So creativity is a very subjective topic. I've discussed the case, and I told you how it is relevant for the sweat of the brow doctrine that is followed in UK. But in US, we see that the court rejected this doctrine and held that in order to be original, a work must not only have been the product of independent creation, but it must also exhibit a modicum of creativity. This doctrine stipulates that originality subsists in a work where a sufficient amount of intellectual creativity and judgment has gone into the creation of that work. The standard of creativity need not be high, but a minimum level of creativity should be there for copyright protection. So, in this case, the question was whether compilation like that of a telephone directory is protected under the copyright law. So the word that we are using here is compilation, and whether it is protected under the Copyright Act. So court held that the facts like names, addresses, etc. are not copyrightable, but compilations of facts are copyrightable. We'll also see in trips how a selection and arrangements are worthy of copyright protection. What do we mean by selection and arrangement is, for example, there are 10 speeches given by, let's say again, Prime Minister Modi ji, and you select that I want to categorize these 10 speeches based on subject matter like foreign relations, inflation, next Ram Mandir, and then you create a collection like 3 speeches fall here, 2 fall here, and 5 fall here. So you have put some sort of skill and judgment into creating this bifurcation. You have put your labor and creativity into determining what the selection and arrangement would be, so you are eligible for copyright. However, in this case, it was further held that there is no minimum creativity that has been put, so it is not worthy of protection, and hence rural's case was dismissed. Next, we come to the position of originality as seen in the Indian jurisdiction, where we follow what we call as the doctrine of merger. So, as I've mentioned, that India strongly followed the doctrine of sweat of the brow, being a former colony for a considerably long time. However, later on, we switched to the understanding. As seen in US, that is the modicum of creativity, and this change specially happened post the case of Eastern Book Company versus DB Modak. And it's in this case what happened was, EBC came up with this edition called the Supreme Court Cases, wherein it was creating a compilation and adding certain additional features, like head notes or giving paragraph numbers to it. And DB Modak used the judgments of the court to create a similar compilation of all the judgments. So in this the dispute was the copyrightability of the judgments that are given by the Honorable Supreme Court. And court noted that copyright protection could be given to the additions and contributions made by the editors of SCC, which included like the head note, as I'm saying, or some additional formatting that they would have done, or like if you're using some databases, you'll see how they have created a special paragraph where they say they summarize the entire decision, like what is in favor, what is in negative. So all of this is protectable, but they cannot have copyright over the judgments that are given by the court, because it is in public domain and everyone has a right to use and publish them. Therefore no copyright can be claimed on the same. And the same is also protected under the Copyright Act, where we see that this section 52, which says tells us that certain acts are not to be infringement of copyright, in which section 52 q 4 tells us that section 52q4 tells us that any judgment or order of a court, tribunal, or other judicial authority, unless the reproduction or publication of such judgment or order is prohibited by the court, the tribunal, or other judicial authority, as the case may be, is not subject to copyright. Like anybody is free to use it and it is in the public domain. So that this is the understanding that we have seen countries have developed over the years through decisions of what originality would mean, and it is still continuing to develop, like based on case to case basis. Now we have disputes arising in terms of work developed through AI, like people are able to create images or literary work through tools such as ChatGPT or DALI, Midjourney, whether it is worthy of giving protection. We have seen in the US that a clear directive has come out that non-human intervention in a case is not in a work is not worthy of protection. It is not original. So we'll continue with some other discussion on the topic later on. If you like it, please leave your comment about what you would like to understand better or what could be improved. Thank you very much.